morning, Your Honors, and may it please the Court. I'm very happy to be here today in Pasadena, and if the Court doesn't have any questions at this time, I would ask to proceed.
Go ahead.
Thank you very much. This case involves parents who've lost custody of their children, and they've lost custody in family court, a court which has completely abandoned and abrogated the Constitution.
So why can't your clients simply appeal in the state courts?
I suppose they could do that.
That's
but
the normal way of dealing with constitutional errors or asserted constitutional errors. So what you're trying seems extraordinary.
Well, I would add that in my experience, the California Court of Appeals has very much the same tack as the family court in that they're just not responsive to constitutional arguments.
And what about the California Supreme Court or the U.S. Supreme Court?
Well, the U.S. Supreme Court, that's the odds of getting hurt are so much less. I suppose that would be an avenue, although
The normal course when you think
Yes.
your rights have been violated by a trial court's order.
yes, and I would agree with Your Honor, but I think the problem is so systemic that if one person were to appeal, we want to change the policy.
Would you agree, Mr. Phillips, that all of the injuries alleged by your clients were inflicted by these state court judgments and orders?
Well, I wouldn't characterize them as judgments. They are temporary orders, but in a civil case, when there's a wrongdoing and there's a judgment that's decided upon, it's decided whether or not a given right was, whether or not a wrongdoing was committed in a typical civil judgment, like in a construction defect case. But it's always temporary when it comes to custody. So,
Sure, but even custody orders that are temporary are appealable immediately, correct?
no, temporary orders are not appealable.
Counsel, I have a different question, if I may, and that is, as I understand it, the Chief Justice is being sued in her official capacity as the head of the Judicial Council for alleged failure to train other judges. Why isn't she not a person within the meaning of Section 1983, because the Judicial Council is an arm of the state of California?
Well, it's our position. We wanted to sue the policymakers for the current policy that's allowed the Constitution to be abandoned and not a specific act of a judicial act. I don't know if Your Honor's question was going towards immunity.
It is going towards immunity, exactly so. So why isn't that fatal to your claim?
Well, because there's no judicial act in question, and it's really not the Chief Justice we're suing. We're suing the council as the
Correct, and the
prosecutor.
council is an arm of the state of California entitled to sovereign immunity.
Well, we believe that there's a different result under Hess, the 1994 Supreme Court case of Hess, which says that if a state agency is financially independent, meaning if they raise their own revenue and pay their own debts, then they're taken outside of the scope of immunity because they're considered independent of that. And so that's the argument under Hess, and all the cases on which our opponents rely conspicuously fail to
Didn't we
mention.
say in Cohn that the treasury element is only one part of it, but there's the dignity element for the state, that we don't infringe on their dignity? And wouldn't suing the state be considered an infringement on their dignity?
Well, I think it could be seen that way, but the reason I don't see it that way is because, I think there's a larger issue. What happens when what if the state of California, state court system, just said no more Constitution? Where would a litigant run to bring the Constitution back?
How about the Supreme Court?
Well, Supreme Court may be a avenue, but it's
Let me try it at a little different angle. Suppose we affirm here, and you think we've got it wrong. Let's say whether it's Rooker-Feldman or
Right.
1983 doctrines or whatever. Do you think you could file suit for damages or an injunction against the Federal Judicial Center and its board and its chair, Chief Justice Roberts?
No, I don't.
Why
I don't
not?
believe so.
Why not?
Because I believe that there would be immunity for the decision, It's a judicial act if the court rules against us.
No, not suing us, not suing the Ninth Circuit judges who were deciding the case, but the Federal Judicial Center trains federal judges, like the state council.
Well, I would say no, because I just don't think that there would be latitude to do that unless there's a policy.
I agree, but I don't see the difference between this case and that hypothetical.
Well, I think the difference is that well, I don't know if the Hess case would apply to the federal judiciary.
It would not.
But I believe that it has applied to state agencies before to take the state agency outside the scope of 11th Amendment immunity.
You're relying on the test that focuses only on an independent fiscal existence, right?
Yes.
Which the Ninth Circuit has rejected in Cone.
Well, I would add,
If we issued the injunction, or if the district court issued an injunction that you've requested against the state judicial council, saying train trial judges differently, how would that change your clients' lives?
well, hopefully it would change for the better of everybody in California. And
How?
well, because they would have the benefits and protections of the
Would be by
Constitution.
the individual decisions of individual judges in individual cases, correct?
Yes.
And the harms that you're suffering are being inflicted, allegedly, by those same sorts of orders. Individual decisions, individual cases, individual judges, right?
Well, yes.
So again, what's the mechanism for remedying the alleged harms by an injunction?
Well, we believe that, if the injunction is granted, we believe it would change the landscape for everybody and would also benefit these parents, because family court cases go on until the youngest child is 18. So presumably they would be benefited in the long run, except for those parents who.
But assuming that the judges follow their training.
Yes. And I would also add, in the Cone case is conspicuously silent about Hess as well. And it seems like every time the Ninth Circuit rules on the 11th Amendment immunity, they completely ignore the words of Justice Ginsburg in the Hess case. And the Supreme Court ruling in Hess, we believe, is respectfully paramount to the Ninth Circuit decisions that hold to the contrary.
I think we attempted to interpret Hess in Cone, but anyway. Do you want to reserve some time for rebuttal?
Yes, I would, please. Thank you, Your Honors.
Good morning. May it please the court. Matthew Green on behalf of Chief Justice Guerrero. I think, as Judge Hamilton indicated here, it is extraordinary what the appellants are attempting to do. They are attempting to hold the Chief Justice responsible for allegedly erroneous child custody orders. The clear remedy in this instance for appellants is to seek appellate review. Appellate review is available in child custody orders, including temporary orders, whether it's by writ relief or by filing appeal. That is the normal course. That is the process.
I ask you I'm from Indiana. I'm the visitor here. Okay. Yes. Can you fill me in a little bit on where to look in California law on that appealability of temporary custody orders?
I don't have a site for you, unfortunately, but it would be under the family code. But for instances where there isn't an immediate right of appeal, there is writ relief available. Similar to coming to this court, writ relief is available. So if there is an emergency need, an urgency, irreparable harm, those sorts of things that can be shown, an aggrieved family court litigant can seek writ relief in the California Court of Appeal. So there absolutely is an avenue. And ultimately, when a child custody order becomes final, there is absolutely a right of appeal in that instance, and that is the proper course.
I'm sorry, go ahead.
Well, no child custody order is ever really final, right? In the sense that it's always subject to modification.
Correct, but writ relief still remains available.
I was just going to ask you if, in your view, Wolf remains good law after Cone in the holding that there's immunity for the Judicial Council.
Absolutely. I think this court ruled appropriately 21